Hi, I'm firearms attorney Gilbert Ambler, and today we're going to talk about a case out of the Middle District of Florida, a decision by Judge Catherine Mizell, I think I'm pronouncing that correctly, that is a very narrow decision. In fact, it applies only to one person because it was an as-applied challenge in a criminal case, which means her decision only applies to that one person who brought the challenge about firearms on post office property. And it was a good decision, but again, only applied to that one person. But the reason we're talking about it is the framework that she used and the reasoning that she applied should apply to a vast number of sensitive places cases because it was very sound reasoning. And essentially, she said all the things that we on the pro-gun side are regularly arguing. So before we dive into that, if you have not yet hit that subscribe button, go ahead, hit subscribe, like, comment with your thoughts, and share with your friends. That way you and your friends can keep getting this important Second Amendment related content. All right, now this decision involved a challenge, a postal worker who was arrested for carrying a firearm on post office property. And he was a semi-truck driver. He would pick up mail, and when he picked up mail, he would have a firearm concealed in a fanny pack on his belt for his own protection. Somehow the post office got wind of this, and two police officers with the Postal Inspector General's office showed up, confronted him. He fled. He was eventually apprehended. He was charged with a crime for carrying a firearm on post office property, a federal crime. He was also charged with eluding or fleeing, something like that, some collateral crime. And he brought a challenge. He brought a constitutional challenge. He said the restriction on firearms on post office property is unconstitutional as it applies to me. Now, the difference between as applied and facial is if it was a facial challenge, the judge would have to find that it applied to everyone, that it was always unconstitutional. He did not bring that type of challenge. He just said, hey, when you look at this law as it applies to me, I'm otherwise a good dude. I'm employed by the post office, and yet I'm getting criminally charged for having a firearm to protect myself. That's unconstitutional as it applies to me. And the government did what the government always likes to do in these challenges, it seems. The government said, we don't have to look at text, history, and tradition. We don't have to look at text, history, and tradition because this is a government building. And all government buildings are sensitive places. Everybody knows that. In fact, go back and look at Heller. Go back and look at McDonald. Go back and look at Bruen. Heller, McDonald, Bruen, all three monumental Supreme Court cases determining the scope of the Second Amendment right. And all three talk about government buildings and sensitive places and lead to the conclusion that we don't have to do text, history, and tradition when we're talking about a government building. And of course, what the judge does is the judge doesn't just buy everything that the government is selling. Because what the government is trying to sell to the judge is what is called dicta. And this is fundamental, basic legal stuff that we need to understand. The holding of any individual case is the rule coming out of that case. So the rule in Bruen was that when there is a Second Amendment challenge, when somebody articulates a challenge involving bearable arms, we need to presume that the restriction is unconstitutional and shift the burden to the government, and the government can affirmatively prove the constitutionality by a text, history, and tradition analysis, if they can show a tradition of similar restrictions dating back to the time of founding. That's the rule that came out of Bruen, and specifically that rule as applied to may-issue states like New York. Now, dicta is all the other things. Now, keep in mind, the Bruen decision, I forget exactly how long it is, but, we're talking about 70 or 80 pages long. So that rule that I just summarized, they take a while to get there. And dicta is all of the other things that the court might say in arriving at their rule. It's not the central holding, it's not the central part of the case, but it's passing comments that they might make. And this is very, very important because the holding, the central rule coming out of the case, is binding on lower courts. So when the Supreme Court says it, all other lower courts need to follow it. Dicta, other comments that they've made, not binding. And what the judge says is if you actually go back and look at the commentary from the court on government buildings in Heller, McDonald, and Bruen, that those comments are dicta only. Because in those three cases, the court was not, in fact, considering a challenge to firearms on government property. And so they made some passing comments. They said things like, our decision today should not, without being further considered, should not cast doubt on the constitutionality of restrictions on firearms at schools and other government buildings, and we assume that government buildings are sensitive. Assuming is different than deciding. And in fact, at the very end of Heller, the Heller court says, with respect to all of those other places we talked about, there will be a time and a place for us to consider them. That was not this instant decision. And Bruen says, remember, the holding in Bruen says, bearable arms challenge, we do text, history, and tradition. So that's exactly what the judge in this Middle District case did. Rather than just buy the government's arguments that this dicta means all government buildings are restricted locations and you can't carry firearms, she said, no, that was dicta. We still need to apply the holding, which is it's a bearable arms challenge. We need to look at text, history, and tradition. And when she did that, she said, aha, there is nothing here that can justify the restrictions on firearms on postal property because all the harms that the government might argue as motivation for this law, general dislike of firearms, keeping postal workers safe from confrontation, these are all things that existed at the time of founding. And so the fact that these same risks existed at the time of founding, and yet our founders did not restrict firearms on these locations, is very strong evidence that any restrictions there are unconstitutional. And what she said was, look, the post office in America dates back to the time of founding. Our forefathers, when they created this country, established the post office before this country was even a country. They established mail runners to run mail through the British lines and to keep communications up. And the risk of them being disrupted by armed individuals existed back then, and yet they did not have a no weapons prohibition. In fact, to the contrary, at times where mail and postal carriers were facing risk of robbery, at times the United States actually armed them to make sure that they could defend themselves. It wasn't until the 1960s, 1970s, and 1980s that we started to see these restrictions on firearms generally on government property and specifically on post office property. And because of that, it fails the Bruen test. There is no tradition dating back to the time of founding. Now, as I said, this decision applies only to the one individual who brought this challenge, but the reasoning should be applied everywhere else. Because when we look at what the government has done, and we see all these states, New York, New Jersey, California, Maryland, Illinois, that have sensitive place restrictions, and they try to argue that, hey, if the government owns the property, it's a sensitive location, the courts there should be applying the test the same way this Middle District judge, who out of interest, I can't remember if I mentioned this, she clerked for Clarence Thomas. So obviously she understood Clarence Thomas must be a sort of mentor to her. Clarence Thomas, of course, authored the Bruen opinion, so it's no wonder that she does an excellent job of following and sticking to the framework that Justice Clarence Thomas laid out in the Bruen decision. If you enjoyed this video, keep an eye. We're going to keep talking about upcoming interesting court cases, especially sensitive place litigation, because there's so much of it going on. Until next time.